Hello and welcome to this Scotland York Intellectual Property Law short webinar. My name is Ben Charig and I'm an associate at Scotland York. The subject matter of this webinar is a new piece of European legislation commonly referred to as the EU Trade Secrets Directive, which came into force earlier this year. The webinar will include a summary of the directive's key points and some discussion of how the directive might affect individuals and businesses in the future. If, after watching the webinar, you have any questions you would like to ask about the directive, please do not hesitate to get in touch with me or your usual contact at Scotland York. Contact details are on the final slide of the presentation. The main objective of the directive is to make trade secret protection more uniform across the EU. The motivation for doing this is that the existing national provisions are felt to be very varied in their form and scope. It is believed that makes it harder for trade secret holders to protect their trade secrets in other countries, e.g. when they're working on cross-border projects or joint ventures. The European Commission hopes that the directive, by attempting to harmonise protection in the different countries, will foster innovation and economic growth. The way the directive approaches its main objective is to provide a set of trade secret-related definitions which must apply in all EU member states, along with a set of remedies which must be available in all EU member states when unlawful acts involving trade secrets are committed. Before we look at some of the definitions and remedies, it's worth noting a few points about the directive. First of all, although the directive is already in force, the EU member states in fact have until June 2018 to comply with the requirements of the directive, so there is still time for member states to make sure appropriate national law is in place. Second of all, although the member states do have to achieve the results specified in the directive, the member states have freedom to determine how they will achieve the results, i.e. through what sources of law and with what details. Third of all, some member states might review the directive and conclude that actually their existing trade secret protection already achieves the results specified in the directive, and therefore that they do not need to implement any changes. The question then is, what sanction can be imposed if a member state has not adequately achieved the results of the directive? There is some European case law which indicates that a member state can be forced to pay damages to an individual or business if the member state has failed to achieve the results specified in a directive and that has adversely affected the individual or business. However, getting those damages might be difficult. And then fourth of all, and lastly on this slide, if the UK leaves the EU, the directive will not apply to the UK anymore. The UK government might in any case be satisfied that national law already achieves the results specified in the directive, but in any case the directive will continue to apply to the remaining member states of the EU after a UK exit. Let's look now at some of the definitions the directive sets out. The first definition to note is trade secret. It appears that this concept is defined very variably in law across the EU member states, so it was one of the priorities for the directive to get right. According to the directive, a trade secret is information which, 1, is secret in the sense that it is not generally known among or readily accessible to people who normally deal with that kind of information, 2, has commercial value because it is secret, and 3, has been subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep it secret. Note that the definition does not restrict the subject matter of the information. This means that a trade secret could be business information, such as a list of clients or suppliers or a sales forecast. It could be technical information, such as a product specification for a not yet released mobile phone or details of a manufacturing process. Or it could be a combination of business and technical information, such as a draft patent application which has not yet been filed. As long as the information meets the 3 criteria stated, it is a trade secret according to the directive. Another of the definitions is lawful acquisition. This is an important definition as it helps demarcate the scope of protection trade secrets are eligible for. According to the directive, acquiring a trade secret shall be considered lawful when the trade secret is obtained by independent discovery or creation, observation, study, disassembly, or testing of a product or object that has been made available to the public, or that is lawfully in the possession of the acquirer of the information, exercise of the right of workers or workers' representatives to information and consultation, or any other practice which, under the circumstances, is in conformity with honest commercial practices. The first 2 points crucially mean that another person or business can independently arrive at or reverse engineer a trade secret without being considered to have committed an unlawful act. The trade secret holder cannot control that other person or business's actions in relation to the trade secret. By contrast, somebody independently arriving at or reverse engineering a patented invention cannot make, sell, use, or import the invention without the patentee's consent. It is therefore important to consider when patent protection might be more appropriate than attempting to keep a trade secret. The directive also provides a definition of unlawful acquisition. According to the directive, this involves unauthorized access to, appropriation of, or copying of any documents, objects, materials, substances, or electronic files which are lawfully under the control of the trade secret holder and contain the trade secret, or from which the trade secret can be deduced. The directive provides an accompanying definition of unlawful use or disclosure, as well as a set of exceptions, i.e. things which are not unlawful, relating to freedom of expression, whistleblowing, disclosure of information by workers to their representatives, and other instances of protecting what the directive calls a legitimate interest recognized by the EU. Let's move on now to the remedies which the directive requires member states to provide. The first remedies discussed in the directive are provisional remedies, i.e. precautionary remedies which can be applied for and, if sufficient evidence is provided by the applicant, awarded before a case has been fully heard. The provisional remedies include prohibiting use or disclosure of a trade secret, prohibiting production, importation, exportation, storage, sale, or use of infringing goods, and seizure or delivery up of suspected infringing goods to prevent their sale. As an alternative to some of the above remedies, a suspected infringer can be allowed to continue alleged unlawful use of a trade secret, provided that the suspected infringer supplies an appropriate guarantee. The guarantee is intended to ensure compensation of the trade secret holder for the continuing alleged unlawful use. In practice, it could be quite difficult for a trade secret holder to provide enough evidence in order for a provisional remedy to be awarded. The applicant must be able to satisfy a judicial authority that the trade secret in question has been acquired unlawfully, that it is being unlawfully used or disclosed, or that unlawful acquisition, use, or disclosure of the trade secret is imminent. The last of these in particular could be very challenging for an applicant to prove. The directive provides some safeguards to ensure that a trade secret holder cannot abuse provisional remedies. For instance, a provisional remedy can be revoked if the trade secret holder does not start full legal proceedings within a reasonable period, or if the trade secret is no longer a secret through no fault of the alleged infringer. Also, a trade secret holder who has obtained a provisional remedy but where there was in fact no unlawful acquisition, use, or disclosure can be made to compensate the individual or business against whom the provisional remedy was ordered. The directive provides a similar set of final remedies, i.e. remedies which are to be awarded after a judicial decision that there has been unlawful acquisition, use, or disclosure of a trade secret. The final remedies include a few extra options, such as ordering the removal of the infringing quality from infringing goods. In cases where the infringer knew or ought to have known that he, she, or it was unlawfully acquiring, using, or disclosing the trade secret, he, she, or it may be ordered to pay damages. The final aspect of the directive I would like to cover is preservation of confidentiality in legal proceedings. In summary, this provision tries to ensure that individuals and businesses are not dissuaded from attempting to assert their rights and protect their trade secrets by the prospect of the trade secrets becoming disclosed during or as a consequence of legal proceedings. According to the directive, Member States must ensure that the parties to legal proceedings, along with their lawyers and other representatives, the court officials, witnesses, experts, etc., are not permitted to use or disclose anything which a judicial authority has identified as confidential and which the parties, lawyers, etc. have become aware of as a result of their participation in the legal proceedings. The judicial authorities may restrict access to documents containing trade secrets, such as documents submitted by the parties, which might otherwise have been made public. They might restrict access to hearings, which might otherwise have been public hearings, and/or they might make available non-confidential versions of judicial decisions in which information relating to trade secrets has been redacted. There are still some aspects of uncertainty about the implementation of the directive. For instance, it remains to be seen which EU member states will conclude that their national laws already achieve the results specified in the directive, and also which member states will feel that new laws or amendments to existing laws will be required. The UK's possible exit from the EU also raises questions about what approach the UK government will take to the directive, given that member states have until June 2018 to comply with the directive. Scott and York will therefore endeavour to provide an update on the directive and its implementation in due course. In the meantime, if you have any questions about the directive, please do not hesitate to contact me or your usual contact at Scott and York. You might also like to watch our recent webinar about the impact of Brexit on patents, trademarks and designs, which you can find on the webinars page of the Scott and York website. Thanks for watching and goodbye.